Hi, and welcome to the Smart Divorce podcast. I'm delighted to be joined today by Judith. Hi, Judith. How are you doing?
Oh, I'm very well, Tamsin. Thank you so much for having me on.
Oh, it's an absolute pleasure. So, Judith is Executive Director and Head of Family Law at Scully & Law, and you might be able to tell from the brief glimpse that Judith is actually Scottish and is based in Scotland. And we're going to be talking today about the Scottish divorce process rather than our normal stance of the divorce process in England and Wales. Judith has been practicing family law for over 20 years. She's accredited family and child law specialist, an accredited mediator, and a collaborative, can't speak today, collaborative lawyer. So she's very much in favour of non-court settlements to divorce, which are, if you've been listening to our podcast for a while, you'll know that we are as well. So we're going to try and start at the beginning today, and we may need to get Judith back for a second go at it if we don't get all the way through. But we're going to try and cover today the divorce process in Scotland, which, as I mentioned, is different to the process in England and Wales. It's governed by a different set of laws. I'm going to hand over to Judith at this point to start to take us through the process, and I'll jump in and ask questions as and when there's anything that sounds similar or that sounds quite different to what we're used to. So over to you, Judith. Where do we start?
Well, thank you so much for that lovely introduction, Tamsin. It's great to be here joining you for this podcast. I'm absolutely delighted to be invited to speak to everybody. And yes, you may hear from the accent, there's a bit of a Scottish twang in there. So everything I'm going to be telling you about today will be about Scots law, Scots family law. And there are differences between how divorce works in Scotland compared to England. So I think the place to begin is probably at your date of separation. Now, that's something which we focus on when we're advising our clients here in Scotland. And we look at a snapshot of the assets and liabilities at the date of separation. Now, there's a bit of a legal definition for the date of separation. It's not so tricky. It's the date that you were no longer living together as husband and wife. So sometimes that date's really clear, and you have a date when one person's moved out of the family home, or you've had a discussion and decided to separate. But sometimes it's not so clear. And there can be disputes about when the date of separation is. But what we look to do is to clarify and agree that at the very beginning, because that's the important date we need to identify. And one of the things to remember is that any assets or liabilities that either you or your spouse acquire after that date, that's not part of the pot that needs to be divided between you. So we look at this snapshot of assets in each spouse's sole name, the joint assets, and we take off the liabilities to get the net position after that at the date of separation. And what we always encourage our clients to do is go through a process which we call full disclosure, which is that each of you disclose to the other through your solicitors all of the vouching for the assets and liabilities at the date of separation. So when it comes to the family home, we would look at what's the outstanding balance on the mortgage, what's the house worth. We would look at bank statements showing balances at the date of separation. We would look at the value of shares and investments at the date of separation. We would look at credit card liabilities, again, showing the balance at the date of separation on the statement, and any other loans and what the outstanding balance would be. There's a couple of other things to think about when we're going through that process. If we're looking at the transfer of a joint home from joint names into one person's sole name, then we look at the net value of that asset as close to the point of transfer as we can, rather than a historical date of separation. And the law on that was clarified several years ago, so that there wasn't this windfall to the person who was taking over sole title to a property if we were to use a date of separation historical valuation. So
So are
that's
you
one thing.
using, do you knock off the cost of sale from the proceeds of the family home? Is that taken into consideration when you're looking at the net value of it?
So the ultimate aim is to enter into something called a minute of agreement or separation agreement. The two things mean the same thing.
Okay.
And standard clauses in the settlement will usually deduct the costs of sale, the marketing and estate agency costs and the solicitor's fees from the net free proceeds to be divided between the parties. So that's
Okay.
more usual than not. So yes, we would look to deduct those costs in the settlement.
Okay. And just a question on the date of separation, because I can only imagine the dramas that must be caused by trying to work out what the date of separation might be if it's not immediately obvious. I'm assuming that, for example, if things were a bit rocky for some time with a couple, and they perhaps were sharing a house but not necessarily sharing a bedroom, for example, and perhaps one of them came into some money through inheritance or what have you, you're going to have presumably a dispute where one party would like the date of separation to be before the inheritance and the other party would quite like it to be afterwards. And I'm assuming that that can be the same with investment value suddenly going up dramatically, or a business suddenly taking off, or any of those types of things. What happens in those circumstances?
So when we're looking at the date of separation and looking at all of the circumstances surrounding that, we look at everything. We look at all of the facts. We look at, where the couple socializing together, were they eating together, were they doing the laundry in the same way as they were before? What did friends and family think was happening in the relationship? We look at all of the circumstances, and sleeping in the same bed is just one of that package of facts that we would look at. And one really pragmatic way forward that I've found is if we're looking at a disputed date of separation and it's quite far apart in terms of the two dates that the couple are proposing, what we can do is value everything at both dates and then make a decision as to whether or not it's really economically sensible to be arguing any more about this. Because basically, if you can't agree, you need to go to court to have something called a preliminary proof, which is just a proof restricted to all of the facts and circumstances about the date of separation, and the sheriff comes down on one date or the other. So there is those options available. You can value at both dates, or you can go to court and have a sheriff make a decision for you.
Okay, and the sheriff is the same as the judge in England and Wales, is it?
Yes, I suppose it's a bit, Robin Hoody, isn't it, that we call them sheriffs? But yes, that's the judges and the sheriff courts. We have a kind of two-tier system in Scotland where we have the sheriff courts, and then we have the Court of Session in Edinburgh. And the Court of Session is really only used where there's extremely high value disputes.
Okay.
And ordinary solicitors can't appear in the Court of Session. We need to instruct a solicitor advocate or an advocate to represent the client there. But the majority of disputes, if they have to go to court, will generally speaking be in the sheriff court.
Okay, and an advocate, just so as to make sure that we're on the same lines, an advocate would be the same as a barrister, would it, in England and Wales?
That's right.
Yeah.
That's exactly right, Tamsin.
Trying my best to keep up with all this new language.
No, you're doing really well. It's really good to get these differences, ironed out so that people aren't confused by
That's
it.
it. No, it's really interesting. Okay, so we're at a point where we've got full financial disclosure from both parties, and they've exchanged that financial disclosure. So England and Wales, we would normally complete a Form E, which is a court form, but the majority of solicitors still ask for that to be completed, even if they're not going to court, and that would be exchanged, which sounds like a fairly similar process. And in Scotland, we've agreed a date of separation to be the date that those assets are valued. That's slightly different in England and Wales. We don't have to agree a date of separation for the asset values. We usually go off current asset values, as long as there's not been a huge distance from the date that they're sorting the finances and the date they actually physically separated. Although actually, I think still we're probably looking initially at current valuations. So where do we go from there then? We've exchanged full financial disclosure.
I think one of the other things to mention that is part of that process is also that we look at pensions. So we've mentioned other investments and liabilities and debts. I think one of the other things to mention is that it's not the value of the pension that comes through in your annual statement that we would use. We would use something called a cash equivalent transfer value, which you ask your pension provider for once you've got your date of separation agreed. And one of the other things to bear in mind is that if that pension has begun prior to the marriage, there's a proportion of it which is not part of the matrimonial pot and should be excluded. And sometimes the pension providers will do that apportionment calculation for us, but if they don't, we do the calculation for the client. And pensions are part of the picture. So once we've been through this process of full disclosure, we will have a schedule made up. We will be able to see what the total matrimonial property is. And then what we do is we look at, well, what is 50% of that total? That is our starting point. The starting point in law is that there should be a fair division of the matrimonial pot, and the starting point is that fair means equal. So we look at what a 50% division is. And if we're just looking at an equal division, we look to see, well, if we divide the joint assets equally, who then has less than half? And who is the person who will need to receive a balancing payment of some description to bring them up to 50% by the other person in the couple. And
Okay,
that's the starting point.
Sorry, do you separate the capital assets, so property, investments, savings, from the pensions? Are those things sorted out separately, or is it all lumped together in one pot?
So yeah,
it's
no,
not a very
it's
technical
really,
question, but
no, it's a really, really good question. We look at the whole picture.
Okay.
But there are, sort of certain limitations on really where we can go with a settlement. If we're looking at a house with equity in it, then, we look at, whether or not one person should receive the full amount of the equity, or, less than that. It depends on the overall picture. When it comes to pensions, they're looked at from the position of, first of all, you could offset your claim. So the person, we could have a settlement whereby they each keep their pensions and neither makes any claim on their pensions. And the division is found through other assets and how they are divided.
Yep.
Or we could have a pension share, which is again made up into this minute of agreement and provided for in the legal document, whereby one person receives a pension credit from the other person's pension fund.
Yeah.
And we have our minute of agreement, and then we have our divorce, and then the pension share is implemented after the divorce. So pensions can be shared depending on what kind of pensions they are, but usually they can be shared. Doing a pension sharing does mean that the whole process of concluding things takes a bit longer and costs a bit more as well. There's just a bit more involved with it, because the minute of agreement, the separation agreement, that has to go to the pension providers for them to approve it before the couple sign it. And then, as I say, you need the divorce before it will be implemented.
Okay. I have quite a lot of questions on pensions, so maybe we need a whole separate episode on pension sharing in Scotland, because there are some pretty big differences, I think, between those. So perhaps we'll concentrate on those another time, so as we don't run out of time on talking about the process. Okay, so we've got the pot of money, and we start looking at 50% each from the whole amount that we're talking about. So where do we go from there?
So the first thing that we look at as a next step from that point is, are there any special circumstances here that we need to take account of, which would allow one person to seek an unequal division?
Yeah.
So there's 4 really common special circumstances that can crop up. It's not an exclusive list, but if there's been a prenup or other minute of agreement that's been entered into, which says what will happen to a certain asset in the event of a separation, then that's something which will usually be applied to a settlement if it's fair and reasonable at the time it was entered into. The other thing to consider is, is any of the property used in connection with a business? For instance, is the family home used to run a business that couldn't be done elsewhere? The most common examples are things like dog grooming businesses, somebody who's living in a home large enough to have that type of business taking place within the property. That's something, an example that's cropped up fairly recently for me.
Okay.
If one of the third most common special circumstances, where one person has destroyed or gotten rid of matrimonial property, and thankfully that doesn't come up very often, but it would involve yes, absolutely, most people have an understanding that that's not going to be the best thing for either of them. And we don't get a lot of people saying, well, I've burned the antique furniture in a pile in the garden, or the paintings got slung on a fire, and things like this. But that's kind of covered, but it's not something that comes up very regularly. I know. So the final most common special circumstances where one person contributes more or has contributed more than the other to the purchase of an asset which is now part of the pot. And the most common example there is where somebody's put down more of a deposit when they've purchased a property. And that would be something where, we would look at, well, there might need to be an unequal division because of the way the asset was purchased, and it was purchased unequally.
Wow. Okay. The special circumstances in Scotland seem to be much more financial, about the financial contributions, whereas they don't seem to consider the not necessarily financial contribution of somebody who might have got less assets. So for example, giving up a career in order to support the other person and look after children. Is that's not taken into consideration at all, or am I
So
missing something?
no, you're not missing anything. That's really what we would look at next. Once we've looked at the special circumstances, what we
Looking
then do
ahead.
is, yeah, we move on to look at what we call our Section 9 principles. And the first one is, has one of the couples suffered any what we call economic disadvantage that's not offset by any economic advantage they've gained? So that would include someone who's given up a career, perhaps they've graduated from university, gone and got married, would have moved into a career, but didn't because the kids came along, and the husband's gone out to work and he's been promoted and he's increased his contributions to his pension, and then at the date of separation you're left with a financially vulnerable woman potentially, and a fairly commercial minded husband. So that sort of circumstance, where the woman has less income prospects and less pension fund, is certainly something that would need to be addressed in order to achieve an overall fair division. So those types of things certainly are looked at, and flowing from that, if one person has been what we call substantially dependent on the other, then we would look at an adjustment to reflect that as well. And we in Scotland, we very much try to achieve a clean break, but
Okay.
it is possible where there's been substantial dependence to secure financial contributions post the divorce, usually for a maximum of 3 years, to allow that person to adjust to their new financial circumstances. It's not always limited to 3 years, but most commonly it is. And I think that's something that's quite different from the English law and how you deal with that sort of situation.
Yeah, absolutely. So that would be equivalent to our spousal maintenance, that 3-year period where there's a possibility that there might be some payment from one party to the other. Or does that include what we would consider child maintenance? Is that 3-year period that overall payment?
So spousal aliment is completely separate to child maintenance. So the spousal aliment is payable up until the point of divorce, and this post-divorce payment is called a periodical allowance, and quite often it replaces the alimentary payment, and takes place after the divorce. So when we're looking at where there's big differences in the earning and income of a couple, then there is an obligation of the spouse with more disposable income to pay for the day-to-day living expenses of the spouse with less disposable income. And what we do is we look at the needs and resources of each of the couple. And when we're considering and assessing whether or not spousal aliment needs to be paid, we ask the couple to disclose to one another basically a breakdown of their income and expenditure. And we have a look at that. And, as long as nobody's got anything, rash, like, thousands of pounds and, a gym membership, or a personal assistant or something like that, we have a good look to make sure that the expenditure is reasonable. And then what we can do is argue for spousal aliment to be paid, to allow that the spouse with less disposable income to meet everyday bills on an ongoing basis.
Okay, and is that, I'm maybe getting confused, is that spousal element that's replaced by the periodic payment, I think you said it was called, is that the 3-year limited amount of money? Is that the same thing, or have I got confused.
No, the spousal element, when it's paid, will be paid right up until the point of divorce. So it just depends how long it takes to get the divorce for that payment to continue.
Okay, and if it turns into the other thing that's available after the divorce, is that the thing that's limited by 3 years?
That's right. The
Right.
periodical allowance is limited to 3 years usually, but if one person's going to suffer serious financial hardship as a result of the divorce, it can be beyond the 3-year period,
Right.
but it's more uncommon.
Okay. Crikey. That really is quite different. Okay, and I don't want to jump too far ahead. So where do we go from that point?
So we're then into a negotiated settlement. Once you're clear on what the picture of the assets is, once you're clear on what the arguments are for unequal division on both sides, we then try to resolve matters by way of negotiation, and that can be, there are different processes to use in all of this. You could just have your solicitor write letters, or you could be engaged in collaboration, and the collaborative process is very much one where the parties are front and centre of all the decisions. The decisions take place at meetings with the clients and their solicitors present. And the only communications between solicitors is to agree an agenda in advance of the meetings and to agree the time and place of the meetings and the format of those. So there's that. There's also mediation. There are lawyer mediators like myself who will take the clients through, full disclosure, and then we'll get both of the couple round the table with the mediator to try and facilitate a settlement, with them again very much being at the forefront of the decision making. So there are lawyer mediators and non-lawyer mediators, and it's probably appropriate to mention that the mediators and also the solicitors involved in any separation we'll also be looking at what the care arrangements are for the children. And you mentioned child maintenance, which is separate from the spousal element. And here in Scotland, I don't think it differs too much, but there's a child maintenance service online calculator. And basically, you punch in gross income and the number of overnights over the course of a year that the paying person sees the children, and you come out with a figure. And that is separate from spousal element, although if the spouse who's due the element will receive child maintenance, that's part of the overall picture of what expenditure and income they have. So child maintenance is sort of a separate thing, and basically, I think the thing to remember with child maintenance is, as I've mentioned, this ultimate aim is to put the settlement into a minute of agreement or separation agreement. One of the sort of strange things about putting in a clause about child maintenance in a minute of agreement is that it will only legally bind the parties for 12 months from the date of second signature to the agreement.
Right. Wow.
And after that, either of them can go off to the child maintenance service and get a maintenance calculation done, and that would overturn the terms of that clause. So it gives a degree of financial security, but only for that 12-month period.
Crikey. Okay, so let's assume for ease that it's been a nice process and the clients have been through mediation and they've come to a nice settlement, decided how to divide their finances. You have written that up into a minute of agreement. What happens then?
So what happens then is that the settlement that's written up into the minute of agreement then gets implemented. So for instance, names are taken off bank accounts, or bank accounts are closed. The family home is sold or transferred into one person's sole name. There could be, you know, the balancing capital payment is made within a certain period of time. And, you know, the whole of the settlement is then implemented. And then the divorce itself, if you've got a pension sharing provision in your minute of agreement, you absolutely 100% need the divorce. But the divorce becomes just a bit of a paperwork exercise. So here in Scotland, most family lawyers won't encourage their clients to go for what we call a fault-based divorce on unreasonable behaviour, adultery. Most family lawyers will encourage their clients to resolve things by way of a minute of agreement and then await a year's separation with the consent of the other spouse. You can apply for a divorce, or after 2 years separation, you don't need their consent and you can apply for the divorce. There's 2 different pathways for the divorce at both of those points. And if there aren't any children under 16, then it's really just a form filling exercise that needs to happen. If there are children under 16, the court needs to be satisfied that the care arrangements for the children are settled and in their best interests. So there needs to be a writ lodged in court, and what we then do is we get affidavits, which are sworn statements from the person who's applying for the divorce, and also from somebody else who can say that all is well so far as the children are concerned. There's a couple of other documents we draft before the divorce application gets submitted to the court, and then a divorce decree is issued. If there's a pension share at that point, there are some strict timescales within which that needs to be implemented. So all of the paperwork about the pension share, the minute of agreement and the divorce decree, that has to go to the pension providers within 2 months of the decree of divorce, and they have 4 months to implement the pension share. And after that, that's pretty much it, you know, and it's done and dusted, and, you know, the client can celebrate that they can move on. Yeah, absolutely. I mean, I have had clients who have had divorce parties because they've been so pleased that the process has come to an end, and it can certainly be a huge relief to people to come through it.
Yeah, it certainly can. I think sometimes there are people who are massively joyful that it's all over and done with. I think there are equally some who are kind of sad that that chapter's closed, not necessarily kind of feeling in a celebratory mood, but I'm sure that you're right. I'm sure that there certainly are people who do. I know Virgin Holidays for a while were selling a divorce holiday to go and celebrate with all your friends that your divorce was over. So I've not seen them advertised for some while, but I have a couple of more questions if that's all right.
Of course.
So in England and Wales, we had the Decree Nice and the Decree Absolute, which some people are still going through those processes because they filed prior to April this year. So there are still Decree Nice and Decree Absolutes that are being processed, that are going through that process. They've been replaced now with the conditional order and the final order. So we have from filing now, there's a 20-week waiting period, then the conditional order can be applied for, and then 6 weeks and a day later, the final order. Do you have, it sounded from what you were saying that your process was quite a lot more straightforward than all of that you apply for the divorce decree and there's kind of not this waiting period, and there's only one decree that gets issued. Have I got that right?
You have pretty much got that right. When the court grants decree of divorce, there is a 14-day period only
Oh, wow.
before the decree is extracted. So we do not have the decree nisi sort of situation that you have in England. It is simply, you know, an extract decree of divorce which is issued,
Wow.
and that's it, done and dusted. So yeah,
Okay.
fairly straightforward.
That's a whole lot more straightforward. And does the minute of agreement need to go to the sheriff to be approved, or is that just drawn up by the lawyers, and as long as the lawyers and the parties are happy, then we're all good?
So it does not need to go to a sheriff in a negotiation. Obviously, you know, if there's a minute of agreement drawn up within court proceedings, that might be lodged as a production to show the sheriff that settlement has been eventually reached despite the court proceedings. But in a negotiated settlement, the minute of agreement, the separation agreement, it's simply registered in the books of counsel in session. And the couple each get an extract bound copy, and the registration means that the terms of the agreement are enforceable. So you could go to court if one person doesn't do what they've said they would in the separation agreement.
Sure. Wow, this is so different. Because sometimes in under England, the law in England and Wales, a couple might agree to agree their financial settlement, but it might be sent into so it then needs to be sent into the court. The financial consent order needs to be sent into the court for the court to assess whether they feel it's fair or not. And very, not commonly, but there are certainly occasions where that would be sent back to the lawyer or to the couple and saying, we don't believe that actually this is fair to both parties, so have another go. So yeah, that really is quite different. Okay, so just I'm aware that I could talk to you for a very long time and I have millions of questions, so we definitely need to do another episode. But just briefly, if we have issues and things are not nice and we're not able to come to a negotiated settlement between the parties, or even using collaboration or mediation, what does the court process look like in Scotland?
Okay, so the court process involves a writ being drafted to crave for the divorce. That crave is just, that's what you seek as your order. So you seek an order for divorce, and you might also seek financial orders. So it would be, I never recommend going to court until at least you have fully disclosed to the other person all of the matrimonial property, the assets and liabilities that you have at the date of separation. And you can then say, well, because of their lack of cooperation, I have had to go to court. They've not given me information. And so, you know, you are protecting your client against any order for them to pay the other side's legal costs if you do that. So the writ is drafted, and the writ has to outline the orders you're looking for. You might look for sale or transfer of the house. You might look for a pension share. You might look for division of bank accounts and a capital sum payment to balance. And in the writ, you have to detail each item of matrimonial property and what it's worth. Once the writ is served on the other person, which can be by recorded delivery or by sheriff officers, what then happens is the defender, the person who's serving the writ is the pursuer, and the person who's receiving the writ being served on them is the defender. The defender then has 21 days within which to lodge a notice of intention to defend the action. And if they do lodge that NID, as we call it, NID, notice of intention to defend, they then have a further period of 14 days to lodge defences, which are answering what is said in the initial writ. And so these form the written pleadings in the court process. And when the NID is lodged, the court will fix something called an options hearing. So by the time of the options hearing, the writ will have been served, the NID will have been lodged, and the defences will be in. And at the time of the options hearing, the court then decides, well, what's to happen with this case? It might be that by raising the court proceedings, you've kind of flushed the other person out, and you can put the court proceedings on the shelf while they give you the information that they've not previously provided. Or it could be that you have to lodge a motion to have the court order disclosure of some of the documents that you've not got. So at the options hearing, the court will decide, well, does this need to go to a full hearing on evidence? And the court will manage the case from there.
Wow, that again is quite different.
Is it?
It is. It seems a very, very different process. You would think that they'd be quite similar as the countries are quite linked, but yeah, there's a huge number of differences. We're kind of running out of time. Is there anything that I should have asked you that I haven't?
I can't think so. All your questions have been great, Tamsin, and I've been so happy to have the opportunity to come on and explain to people how we do things in Scotland. So thank you so much for having me.
So my absolute pleasure. We definitely need to get you back because we need to cover pensions in Scotland to a much greater extent than we have already. So if you'd be happy to come back, we'd love to have you back again.
Oh,
And
thank you
we'll
so
do that.
much.
Fantastic. And for anybody, any of our listeners who are in Scotland and need some help with their divorce, because I'm sure there are many people listening who will be in that circumstance, how can they get hold of you, Judith?
So please do reach out if you're in need of any advice at all in relation to the family law in Scotland, be that financial or in relation to the childcare arrangements. You can reach me at Scullion Law. Our website is scullionlaw.com and our phone number is 01698 283 265. Just give us a buzz.
Fantastic. And we'll make sure that both the website and the telephone number are in our show notes. If you do want to contact Judith about anything, I'm sure she'd be delighted to hear from you. So it just remains for me to say thank you, Judith, for joining us. It's been an absolute pleasure and a real insight to speak to you today. And to everybody listening, thank you for listening. And we look forward to talking to you again soon.
Thank you.